Question Document Examination. Compiled by Larry L. Lopez. Introduction. Question Document Examination, QDE, is a forensic science discipline pertaining to documents that are potentially disputed in a court of law. The examination's primary purpose is to provide evidence about suspicious or questioned documents using a variety of scientific principles and methods. Document examination might include alterations, obliterations, paper analysis, forgery, origin, determining authenticity, or any other questions. The profession of forensic document examiner, FDE, or examiner of questioned documents, grew out of the court's need for assistance in interpreting evidence relating to the preparation and subsequent treatment of documents. It is actually a pure forensic science in that it developed within the legal system rather than as an extension of other professions, such as medicine, dentistry, chemistry, or engineering. Forensic science is the application of science to the law. Forensic document examination, latent print examination, DNA, forensic imaging, pathology, drug chemistry, and physical chemistry all fit this description. Forensic document examination is often overlooked and misunderstood by the public. American Society for Testing Materials, ASTM, describes the work of FDEs thus: the forensic document examiner makes scientific examinations, comparisons, and analyses of documents in order to 1. Establish genuineness or non-genuineness, or to expose forgery, or to reveal alterations, additions, or deletions. 2. Identify or eliminate persons as the source of handwriting. 3. Identify or eliminate the source of typewriting or other impression, marks, or relative evidence. And 4. Write reports or give testimony, when needed, to aid the users of the examiner's services in understanding the examiner's findings. Forensic document examiner, question document examiner, document analyst, document examiner, and handwriting expert are all titles applied to practitioners. Handwriting expert is not completely accurate because the work involves more diverse examinations than simply handwriting. Most practitioners today refer to themselves as forensic document examiners. General definition of terms. Document. Any material containing marks, symbols, or signs either visible, partially visible or invisible that may presently or ultimately convey a meaning or message to someone, may be in the form of pencil, ink writing, typewriting, or printing on paper. Questioned. Any material which some issue has been raised or which is under scrutiny. Questioned document. 1. In which the facts appearing therein may not be true, and are contested either in whole or part with respect to its authenticity, identity, or origin. It may be a deed, contract, will, election ballots, marriage contract, check, visas, application form, check writer, certificates, etc. Disputed document, a term suggesting that there is an argument or controversy over the document, and strictly speaking this is true meaning. In this text, as well as through prior usage, however, disputed document and questioned document are used interchangeably to signify a document that is under special scrutiny. Standard, also known as standard document, are condensed and compact set of authentic specimens which, if adequate and proper, should contain a cross-section of the material from a known source. Exemplar. A term used by some document examiners and attorneys to characterize known material. Standard is the older term. A sample of specimen considered authentic. Holographic document, any document completely written and signed by one person, also known as a holograph. In a number of jurisdictions, a holographic will can be probated without anyone having witnessed its execution. Reference collection, material compiled and organized by the document examiner to assist him in answering special questions. Reference collections of typewriting, check writing specimens, inks, pens, pencils, and papers are frequently maintained. Definition of some terms. A. Addition. Any matter made a part of the document after its original preparation may be referred to as addition. Conclusion. A scientific conclusion results from relating observed facts by logical, common-sense reasoning in accordance with established rules or laws. The document examiner's conclusion, in legal term, is referred to as opinion. Document examiner, one who studies scientifically the details and elements of documents in order to identify their source or to discover other facts concerning them. Document examiners are often referred to as handwriting identification experts, but today the work has outgrown this latter title and involves other problems than merely the examination of handwriting. Erasure, the removal of writings, typewriting or printing, from a document is an erasure. It may be accomplished by either of two means. A chemical eradication in which the writing is removed or bleached by chemical agents, example liquid ink eradicator. And an abrasive erasure is where the writing is effaced by rubbing with a rubber eraser or scratching out with a knife or other sharp-with implement. Examination. It is the act of making a close and critical study of any material, and with questioned documents, it is the process necessary to discover the facts about them. Various types are undertaken, including microscopic, visual photographic, chemical, ultraviolet and infrared examination. Expert witness. A legal term used to describe a witness, who by reason of his special training or experience is permitted to express an opinion regarding the issue, or a certain aspect of the issue, which is involved in a court action. His purpose is to interpret technical information in his particular specialty, in order to assist the court in administering justice. The document examiner testifies in court as an expert witness. Handwriting identification expert. A common name for the document examiner. Identification, identity. As used in this text, it is the state of being identical or absolutely the same, as in similarity of source or authorship of the questioned document and the standard document. Insertion or interlineation. The term insertion and interlineations include the addition of writing and other material between lines or paragraphs, or the addition of whole page to a document. Non-identification, non-identity. As used in this text, it means that the source or authorship of the compared, questioned and standard specimens is different. Obliteration. The blotting out or smearing over the writing, to make the original invisible to as an addition. Opinion. In legal language, it refers to the document examiner's conclusion. Actually, in court, he not only expresses an opinion but demonstrates the reasons for arriving at his opinion. Throughout this text, opinion and conclusion are used synonymously. Qualification. The professional experience, education, and ability of a document examiner. Before he is permitted to testify as an expert witness, the court must rule that he is qualified in his field. Legal basis of documents. In the case of People v. Moreno, Court of Appeals, Volume 338, Official Gazette, page 119. Any written document by which a right is established or an obligation is extinguished. In the case of People v. Niliskin, Court of Appeals, Volume 48, Official Gazette page 4453. Every deed or instrument executed by person, by which some disposition or agreement is proved, evidenced, or set forth. In relation to criminal jurisprudence under the best evidence rule. Any physical embodiment of information or ideas, example. A letter, a contract, a receipt, a book of account, a blur print, or an X-ray plate. Kinds of document. Public document. Notarized by a notary public or competent public official with solemnities required by law. Cacneo vs. Baines, Volume 5 Philippine Report, page 742. Official document. Issued by the government or its agents or its officers having the authority to do so, and the offices, which in accordance with their creation, they are authorized to issue and be issued in the performance of their duties. Private document. Executed by a private person without the intervention of a notary public or of any person legally authorized, by which documents, some disposition, or agreement is proved, evidenced or set forth. U.S. vs. Ora, Volume 11, Philippine Report, page 596. Commercial document. Executed in accordance with the Code of Commerce or any mercantile law, containing disposition of commercial rights or obligations. Writings which do not constitute documents. Based on some Supreme Court rulings. A draft of a municipal payroll which is not yet approved by the proper authority, People v. Camacho, Volume 44 Philippine Report page 484. Mere blank forms of official documents, the spaces of which are not filled up, People v. Santiago, Court of Appeals, Volume 48 Official Gazette page 4558. Pamphlets or books which do not evidence any disposition or agreement are not documents but are mere merchandise, People v. Agnes, Volume 47 Philippine Report page 945. Classes of questioned documents. 1. Documents with questioned signatures. 2. Questioned documents alleged to have been containing fraudulent alterations. 3. Questioned or disputed holographic wills. Such as, holographic will entirely written in the handwriting of the testator. And notarial will, signed by the testator, acknowledged before a notary public with 2 witnesses. 4. Documents investigated on the question of typewriting. Such as those, A. with a view of ascertaining their source, B. with a view of ascertaining their date, C. with a view of determining whether or not they contain fraudulent alterations or substituted pages. 5. Questioned documents on issues of their age or date. 6. Questioned documents on issues of materials used in their production. 7. Documents or writings investigated, because it is alleged that they identify some persons through handwriting. Such as, A. Anonymous and disputed letters, and B. Superscriptions, registrations, and miscellaneous writings. Types of document standards and characteristics. The following terms are technically defined as standard. They are known writings which indicate how a person writes. A writer manifests fixed habits in his writings that identify him. This fact provides the basis for an opinion of conclusion regarding any writing identification problem. Exemplars. Specimen of the writing of suspects are commonly known as exemplars. The term standards are a general term referring to all authenticated writings of the suspects, while exemplars refer more especially to a specimen of standard writing offered in evidence or obtained or request for comparison with the questioned writing. Sample of specimen considered standard. Sample, a selected representative portion of the whole is known as a sample. Useful suggestion regarding handwriting standards for comparison. Types of handwriting standards. Collected standards are known, genuine, handwriting of an individual such as signature and endorsements on cancelled checks, legal papers, letters, commercial, official, public and private document, and other handwriting such as letters, memoranda, etc. Written in the course of daily life, both business and socials. Requested standards are signature or other handwritings, or handprintings, written by an individual upon request for the purpose of comparison with other handwriting or for specimen purposes. Post litem motam exemplars, writings produced by the subject after evidential writings have come into dispute and solely for the purpose of establishing his contentions. Disguises in handwriting. Common disguises: abnormally large writing, abnormally small writing, alteration in slant, usually backhand, usual variation in slant within a single unit of writing, within a single signature, printed forms instead of cursive forms, diminution in the usual speed of writing, and unusual widening or restriction of lateral spacing. Kinds of disguises. Change of slant, from right to left or vice versa. Change of letter, either from cursive to block style or vice versa. Change from cursive, conventional style, to block form or vice versa. Change of style from small to big or vice versa. Deteriorating one's handwriting. And using the wrong hand, ambidextrous. Signature identification, types of signature, areas of signature identification, and methods of signature examination. Investigation and detailed examination of signatures. Signature: it is the name of a person written by him/her in a document as a sign of acknowledgement. Or, it is a name or a mark that a person puts at the end of a document to attest. Other significant terms. Assisted signature. See guided signature. Cross mark: historically, many who could not write signed with a cross mark or crude X. This authenticating mark is still used today by illiterates, and if properly witnessed, it can legally stand for a signature. Ballot marks are also referred to as cross marks because of the common practice of marking with an X. Evidential signature is not simply a signature, it is a signature, signed at a particular time and place, under particular conditions, while the signer was at particular age, in a particular physical and mental condition, using particular implements, and with a particular reason and purpose for recording his name. Fraudulent signature, a forged signature. It involves the writing of a name as a signature by someone other than the person himself, without his permission, often with some degree of imitation. Freehand signature, a fraudulent signature that was executed purely by simulation rather than by tracing the outline of a genuine signature. Guided signature, a signature that is executed while the writer's hand or arm is steadied in any way. Under the law of most jurisdictions, such a signature authenticates a legal document provided it is shown that the writer requested the assistance. Guided signatures are most commonly written during a serious illness or on a deathbed. Imitated signature, synonymous with freehand forgery. Model signature, a genuine signature that has been used to prepare an imitated or traced forgery. Theory of comparison. The act of setting two or more signature in an inverted position, to weigh their identifying significance, the reason being that those we fail to see under normal comparison may readily be seen under this theory. Types of signatures. Formal, also known as conventional or copybook form, informal or cursory, and careless scribble. Formal, also known as conventional or copybook form, complete correct signature for an important document such as will. Informal or cursory, usually for routine documents and personal correspondence, such as 1. Personalized. 2. Semi-personalized. Careless scribble for the mail carrier, delivery boy, or the autograph collector. Disclaimer: the information presented here is merely a collection for respective teaching assignments. Various sources as listed at the end of the presentation as well as freely available material from Internet were consolidated to prepare this learning materials. The ownership of the information lies with the respective authors or institutions.